Ready. Start. Separately to upgrade the Galaxy software to version 4.5 for security reasons and for protecting its intellectual property rights to prevent further privacy of its products and software. The main grievance of the original plaintiffs is the locking out, shutting down the machines by original defendant number 1 appellant herein through a server in Israel as a result of original plaintiffs' failure to upgrade the software, which, according to original defendant number 1 appellant herein, tantamount to a material breach of the agreements. It is not disputed that the machines in question were sold and the software in question was licensed by original defendant number 1 appellant herein to each of the original plaintiffs by way of separate agreements. It is also not original plaintiff's case that they had not upgraded the software on previous occasions as and when such upgrades were released by the original defendant number 1 appellant herein. It is also an admitted fact that the original defendant number 2 has provided advisor software to each of the original plaintiffs separately and that the machines in question and the software in question was provided by original defendant number 1 appellant herein and not original defendant number 2 respondent number 14 herein. It is also an admitted fact that original defendant number 3 respondent number 15 herein only provides service and maintenance support for the machines and software provided by the original defendant number 1 appellant herein to each of the original plaintiffs. It is also an admitted fact that original defendant number 4 to 6, respondent number 16, 17 and 18 herein are only offers of the original defendant number 1 to 3 companies and have no direct or indirect role in their individual or personal capacity distinct from that of their official capacity in respect of the subject matter of the issues raised in the present suit. Rather, the original plaintiff's entire case is directed against original defendant number 1 alone. The reliefs sought in the suit are clearly and unambiguously directed against original defendant number 1 appellant herein alone, as the said reliefs on a plain and meaningful reading are capable of being enforced against original defendant number 1 alone.